Hi, and thanks for joining us in the Talking Animals Law and Philosophy series. This is our last event this term, and we're very excited to have one of our visiting researchers with us. As some of you may know, my name is Raphael Fezel. I'm the Executive Director of the Cambridge Centre for Animal Rights Law. Before we get started with our talk, just a few notes on housekeeping. So the talk will last for about 30 to 40 minutes, and we will then have plenty of time for our discussion. As always, you're very welcome to join in the discussion. So if you have any questions or comments, please do come in. You can do so using the raise hand button. You'll find it under reactions on the bottom, the little smiley face. If you cannot locate raise hand, feel free to also use the chat instead. That works as well. And then also feed your questions and comments to our speaker, who will be responding to you. Until that point, I will be muting all the microphones so we can focus fully on our speaker. Let me see. We are also recording the talk itself. So if you want to watch it later or send the link to a friend, you're very welcome to do that. It will be uploaded to our website tonight or tomorrow or so. Okay, great. So with that out of the way, it is now my pleasure to introduce our speaker today, and that's Miss Carolina Leiva Ilabaca, who, as I mentioned before, is a research visitor at the Cambridge Centre for Animal Rights Law. Carolina is also a PhD candidate at the Universities of Chile and the University of, or the Autonomous University of Barcelona. I'm not going to attempt to pronounce it in Spanish. Carolina is currently in the final stages of writing up her PhD entitled Animals as Victims, Basis for a Dogmatic Reconstruction of the Animal Mistreatment Penal Type in Chile. Carolina received her LLB from the Catholic University of the North in Chile, and she holds a master's degree in animal law and society from the Autonomous University of Barcelona. In Chile, Carolina practiced as a lawyer before the Supreme Court, and she taught animal law in a number of law faculties and veterinary science faculties, including at the Catholic University of the North and the University of Chile. Carolina, as some of you may know, has also published widely on animal law matters. I'm not sure if wildly also, but I'm sure widely. Carolina's research at our center is focused on examining different approaches to the concept of subjecthood in general and animal subjecthood in particular. And her aim is to see if we could possibly ascribe legal subjective rights to non-human animals. Today in her presentation, she'll be exploring some of these themes with us, and the title of her presentation is Exploring the Foundations for Legal Animal Rights Towards a Sentience Interest Pragmatic Account. Carolina, thanks so much for being with us. The floor is yours.
Thank you so much, Raphael, for having me, and especially for having me during this Lent here. It has been so far an incredibly amazing experience. Well, I'm glad and honored to be presenting today part of my research, and I'm going to start sharing my screen. Yes, here it is. Just a second. There it goes. Everybody can see it?
Yes, looks great.
Great, thank you very much. Well, as the original name of this talk was, if some of you have seen before in the webpage of in the site of the center, the former name of this talk was Opening the Toolbox Prolegomena for the Ascription of Legal Subjective Rights to Animals. But rather, I have decided to introduce this presentation with a different title, a title which aims to embrace more clearly the main scope of this research, of this ongoing research. And that is the one that you have already seen and Raphael has kindly introduced, that it's exploring the foundations for legal animal rights towards a science interest pragmatic account. Certainly, This is about work in progress, and for that reason, I am more than grateful in advance for any comment or suggestion that you could make by the end of this presentation, of course. So let me start with a few words about what are we going to explore today. In first place, we are going to take a look into the main questions that motivate this work. In second place, I will guide you to what I have called the meeting, where we will meet some of the most compelling arguments that it is possible to find in the literature of the most compelling, in the literature to respond to these questions that I will present before. And as you will see, I have separated these arguments into families, and we will meet these two families. In third place, I will briefly test the performance, both in theoretical and in practical grounds, of each of these two families. In fourth place, I will present the findings, namely some of the conclusions that have emerged from the test so far. And finally, I will present to you what could be seen as a proposal for a future development. So let's start with the questions. As it comes halfway clear from both titles that I have been showing to you so far, the main question that I tend to respond by this research is roughly, can non-human animals hold right? I know it is not a very especially original question, but the thing is that even though it's still a pressing question, I have not come to the necessity of respond to it from out of nowhere. I have arrived at this question from some other previous questions which have emerged during my doctoral research. So to make the scope of this presentation more clear, as also to clarify the reasons that lays behind the big question it aims to respond, let me walk you briefly through what is the background of my research. Roughly speaking, my ongoing dissertation concerns the main following question. Can non-human animals be considered as victims? Mainly, of course, as victims of anti-cruelty crimes? Both questions, the general about animal rights and the more particular about victimhood, have in turn two identifiable origins. On the one side, they have an origin as a theoretical challenge, as it seems that it is a topic not exhaustively explored by the specialized literature, the one of victimhood, not the one of rights, that it has been exhaustively explored. And on the other side, they have an origin on practical reasons. In my professional experience as a lawyer and as a legal advisor to members of the Chilean Parliament, as well as to several NGOs involved in animal protection, I have experienced the practical problems that arises from the fact that animals are placed in a sort of legal limbo among our legal systems. That is, protected by several legal provisions, which could be seen as a sort of subjectivization of animals as opposed to a reification or objectification, if I may use these terms, while at the same time, they are still considered as things for the most of legal purposes. So considering these origins, theoretical and practical at the same time, the research for possible answers and the answers itself must accomplish with two main requirements. In the first place, it must be theoretically strong as much as, in the second place, it has to be pragmatic. Both requirements imply, in turn, running away from any possible response which only aims to sustain animals' consideration exclusively on moral grounds. Put differently, away from reasons that impose animal consideration as the right thing to do from an exclusive normative perspective. So let's now return to the original question and how it progresses by the course of this research. From my doctoral research original question, which is, can non-human animals be considered as victims, emerges the necessity to clarify some other previous issues, which can be seen as sub-questions that flows from the main one. Put it differently, while working on the field of victimhood, several other questions about general subjecthood came out. To answer all of these questions and sub-questions, I have resorted to the tools provided from different fields of law, namely and mainly from criminal law theory on the one side and from legal theory on the other side. Some of these sub-questions are, grosso modo, the ones that I'm showing to you here. In first place, of course, what it is a victim, to which I am responding, of course, very roughly speaking, that it is the holder of the legal good protected regarding continental law tradition, or the holder of an interest that enjoys a criminal protection against wrongful harms concerning common law tradition. A second question that arises from the previous one is, what is then a legal good protected? And also, what is an interest criminally protectable? In third place, who can therefore hold legal goods or criminally protected interest to, on that regard, can be properly be considered as a victim? In fourth place, is it possible to consider that a legal good protected is the same thing as the criminally relevant interest in common law? And therefore, if that is so, who or what can have interest? Is it necessary to be a subject to do so, namely not an object? Subsequently, what it takes to be considered a subject? Is it necessary to be a person? Is it necessary to hold rights? I know there are too many questions. Therefore, what it is a right then, and assuming an interest theory of rights approach, as I do, as you will see furthermore, does this mean that a legal good protected is therefore the same thing as a right? And finally, the main question, but not the last but not the least, the question among all questions, can non-human animals hold rights? Can be considered as right holders? These are some of the multiple questions that arises from the main and original one. Among all of them, I will focus today especially on sharing with you how I am managing to respond to the last question, namely, can non-human animals be considered as right holders? Well, first thing I have faced when getting at work about this issue is the assertion that only persons, whether natural or juristic, can be right holders, and that they are so because they are in turn capable of holding duties. Reciprocity seems to be here a main feature of right holding. As it is evident, this assertion comes certainly with a little problem. Animals are considered as objects and not as persons, and this is so even among some legal systems that have removed animals from the category of things by declaring them that they are explicitly not things, such as the case of France and more recently the case of Spain. What to do, therefore, to make possible to consider animals as right holders? At least three possibilities arises. In the first place, the possibility to include animals within the category of persons. In second place, demonstrate that the assertion that only persons can hold rights is false by proving that non-persons can be also right holders. And in third place, create a third new category which breaks the principium tertii exclusive that has ruled for centuries, just allowing the existence of only persons and things in law. To explore these different proposals, it is mandatory to address, first thing, the notions of personhood and how this notion relates to the notion of rights. To this task, I have analyzed several approaches which aims to address the concept of personhood in general and of legal personhood in particular, and how it relates with the right holding issue. In other words, I have carried out a study of diverse accounts which aims to explain right holding by focusing on the kind of entities that qualifies as possible right holders. Across this analysis, I have come to distinguish two general approaches concerning this broad question about right holding. In the first place, it is possible to distinguish a general approach that sustains that only persons can be right holders, and in second place, a general approach that sustains that not only persons can hold rights, implying that entities different than persons are able to do so, as it could be the case, for instance, of non-human animals. For a better understanding of this distinction, I have identified both general approaches as families, composed by different members that, though in several ways related, they are not exactly equal to one another. Regarding the main characteristics of each family, I have named them as the Excluding Personhood family, or EPF, and the Non-Excluding Personhood family, or NEPF. So let's meet the families now. I will pass to the second part, the next part, of this presentation, which is the meeting. Let's start with the first family, the Excluding Personhood family. As I already pointed, the members of this family group shared a common DNA, which is the general consideration that only persons can be right holders. Nonetheless, as it is the case for any individual member of any family, they vary in several areas, such as which are the necessary conditions to be considered a person, or about what being a person really implies, or which are the consequences that flows from the status, and so on. In the following, I will briefly present some of these family members by distinguishing what they consider as the necessary and sufficient condition for personhood, and I will do so highlighting some of the accounts offered by the literature. Here I have distinguished, again, three general groups of relatives. In third place, we will see the end in itself family group. In second place, the mental attributes family group. And in third place, the conventionality family group. So in the first family group, the end in itself, the main feature that the authors that participate in this family consider that what is needed to be considered a person and therefore a right holder is the consideration of an end in itself of a given entity. We can name here two conspicuous members. In first place, Immanuel Kant, who argues, roughly speaking, that only persons can hold rights, only human beings are persons, and they are ends in themselves, are persons as they are ends in themselves, and that they are so because they are endowed with reason, autonomy, and dignity, and therefore they are full moral agents. Animals, on the contrary, and because they lack these features, are not ends but means, and they don't have dignity but a price. Christine Forsgaard, in turn, also roots personhood in the end in itself quality, but contrary to Kant, allows the consideration of animals as ends in themselves, resorting this allegation on their capacity for sentience, feature that supports their possession of interests. Afterwards, we find the mental attributes family group, where all members coincide on the assumption that the necessary and sufficient conditions to be a person is being in the possession of certain mental attributes, such as reason or sentience. We can find examples on the former on Descartes and Locke, excluding animals, of course, and of the latter on scholars as different as Singer, Francione, and Regan, though this time including animals. Maybe you are wondering now, why am I not including here the members of the first family as well, as they are also resort their accounts in some capacities as reason or sentience. But the thing is that I prefer to do it this way because they do not, the first family, connect directly with the mental capacities with personhood or rights, but they do so mediate by the less objective, in my opinion, feature of having a value as an end in itself, which implies, again, in my opinion, a normative metaphysical feature not demanded by the members of the second family. And finally, we meet now the conventionality family group, the last familiar group of this big family. In this group, we find those proposals that explains personhood in a convention, in a declaration. To this group, a person can be anything that the decision makers want it to be. This family is consistent with which Nafin identifies as the legalist group, a group that does not engage with natural, ontological, nor metaphysical questions, remaining therefore on the sphere of the institutional decisions. Let's address now the non-excluding personhood family, the second main approach. As already mentioned, here we can find those approaches that consider that entities different than persons can be right holders. Among these, it is also possible to distinguish, as in the previous family, different relatives regarding if they defend a position which sustains that things or property can hold rights, or if rather they defend the necessity for creating a new category of right holders, different than persons and things. For sure, the names that I have given to these approaches are tentative. Happy to hear suggestions if you have some ideas, but for the moment, they can be identified as the rights beyond personhood family group and the rights independent from personhood family group. In the first place, within the rights beyond personhood family group, we can find those accounts that sustains that not just persons can hold rights, arguing that also non-persons or more directly things or property can also do so. This is the case for authors like David Faber and its living property proposal, as well as the main contribution made by Kurki, who argues in favor that the so-called thinghood, that is the quality of being a thing, permits right holding, as it has been proved by the current existence of welfare laws and animal protection prescriptions, as well as it was in the past regarding slavery in ancient Rome and during the antebellum period in the US. More recently, by his bundle theory of legal rights, the author enforces these ideas by showing how personhood is a cluster concept composed by several active and passive incidents, and how non-human animals are in possession of some of them, especially the passive ones. By these findings, the author sustains that even though animals are not in possession of the whole pool of incidents, they do possess the ones that are necessary to hold rights, which are specifically the passive incidents. And finally, we meet the rights independent from personhood family group, where we can find different accounts that argue in favor of the of the end of the classic person-thing bifurcation by means of the creation of a new third category. Among this group, highlights proposals as Thomas Piotrowski, non-personal subject of law, on which he proposes that the members of this category shall be recognized as possessors of one subjective right, namely the right to have their interests considered relevant in any decision that could affect their fulfillment. Another example is the one offered by Farjat and its center of interests, among which the author includes also families, companies and networks, fetuses, ships and vessels, corps, and of course, non-human animals, among other entities. So having shown how these families are composed, and by that, I have been trying to present the main arguments that are on the table about this discussion. It's time to pass to the test. So regarding the need for responding to the questions that motivates this presentation and the aim to do this by fulfilling the two requirements announced at the beginning, that is theoretical strongness on one part and pragmatical feasibility on the other, let's see how these families and their members behaves on legal grounds. Let's begin with the excluding personhood family. At least in paper, it seems to be the most powerful family, as it still present in the most part of legal systems, and it is how lots of courts react by the time of granting legal rights to animals. But this argument can be seen not only in the way that judges responses, but also in the allegation of animal rights attorneys. For example, this is exactly the way on which the non-human rights project sustain their arguments, namely, A, as certain animals possess certain characteristics, same characteristics that allows the consideration of humans as persons, such as sentience, consciousness, self-determination in some cases, and so on, they should be declared as persons too, to therefore be granted with some legal rights. Nonetheless, this argument fails each time it is confronted to the assertion that de lege lata, animals can be considered today as right holders regarding animal welfare laws or even the criminal provisions that sanctions animal mistreatment and cruelty. Also in practice and in my own experience, for what is worth, I have seen how judges, executive authorities, and lawmakers wrinkle their noses in front of the idea of placing non-human animals in a kind of a same position as human beings. I call this the nose wrinkling argument, composed by all the arguments that aims to avoid animal personhood on the grounds of protecting human rights and or human dignity. So considering these two circumstances, the theoretical one and the practical one, it is possible to sustain that probably this family, though it is a powerful family, it is not that strong family. Just for graphic purposes, this is how the wrinkling nose argument looks like. And it's a gesture that it's usually followed by a sound that makes like something like So let's see now how the non-excluding personhood family passes this test. Even when this family could be considered as a less validated position, and maybe even a bit disruptive, this family seems to avoid the two main problems faced by the previous family. In first place, from an interest theory of rights perspective, in opposition to the will or choice theory of rights, such as the one offered, for instance, by scholars as Matthew Kramer, it is possible to sustain that non-human animals already hold rights without the need of any declaration of personhood. Being this so, and departing from the assertion that animals possess interest, as we can learn from the inputs that comes from biological science, for instance, we can positively argue in favor of a consideration of animals as right holders de lege lata. Also, this is consistent with what we can find in the most part of legal systems regarding the existence of animal welfare, animal protection provisions, and anti-cruelty laws. And finally, this family group succeeds avoiding the noise wrinkling argument by means of not getting into the category of persons. Nonetheless, there still be a problem with this family. There still is a problem. It is, for many, a complicated to intellectual family, which finds a difficult way through convincing judges, lawmakers, and other authorities who are, in most of the cases, sadly, poorly prepared on theoretical grounds and therefore not especially open to this kind of argument. In conclusion, even though this family is a very strong family, is at the same time less powerful. Again, just for graphic purposes, this is how this family looks like for practitioners. Like a Victorian family reading all together and not getting involved with what is going on outside their beautiful houses. So, being this so, we find ourselves in a zero-sum situation. We get stuck between a very powerful family without strong arguments and a less powerful family, but with very strong arguments. How can we move forward? So now let's pass to the findings. A way to move forward is by identifying the most compelling arguments or elements on both families. Doing this, I have come to find the next nuclear core, namely the sentience interest core. This core can be well resumed on what Raphael Fasel, with your permission, has identified as the meritocratic conception of fundamental rights, which, even though it is a conception regarding the recognition or the ascription of fundamental rights, it is nonetheless, mutatis mutandi, extremely useful for these purposes as well. As Fasel has pointed out, the meritocratic conception is based on merits and deserts. Regarding non-human animals, a special situation, merits are given by some of their features, mainly sentience, which permits us to sustain that they have what it takes to possess interest. According to the author, it is possible to highlight three main characteristics of this conception. I name these characteristics and I present this conception because it represents very accurately this core that I am distillating from all the families. First, the differential consideration. This characteristic of this conception implies that three central components. First, merit, that is that the right depends on the entity's characteristic. Second, gradualism, referring to a gradual distribution of rights regarding those characteristics. And finally, inclusivity, meaning that entities can hold rights regarding their features and independently of their species. A second important characteristic is patient focus, which implies the adoption of an interest-based approach to rights, the rejection of the need for reciprocity, and interplays a relativist conception of fundamental rights, that rights will be submitted to a balancing exercise in each situation that can be confronted with another fundamental rights, and interplays externalism, regarding that this conception explains rights and facts about the world and not on merely internormative ideas, as it is the case of the presence of sentience. So as we saw, in both families, it is possible to find at some point the common stand that special capacities or merits can grant legal rights. Nonetheless, one family, one of the families argues that for doing so, a declaration of personhood is needed, while the other family does not demand any declaration at all. So to finish, let's take a look into the proposal for a future development. Well, in conclusion, there are good reasons to argue in favor of developing an account that, containing the core already mentioned, that it's, as I said, very well represented by what Facel has pointed as the meritocratic conception. And this core is the science interest core, but also relying on the strong background provided by the second family, presents their main components in a simpler way. Meaning, these are what I think, in my opinion, could be the main elements for a theoretical, pragmatical, strong approach. First, that animals are sentient beings. Second, as animals are sentient beings, they have interests. Legal interests are legally protected. I'm sorry. Legal rights are legally protected interests. Legal systems already protect animal interests. Therefore, legal systems already contemplate animal legal rights de lege lata. I have called this the sentience interest pragmatic account, an account that, mediating further development, of course, could be enough strong and powerful on theoretical grounds, but also for legal practical purposes. Namely, it could be suitable for the rights holding, and it also could be suitable for criminal purposes as well, by means of enabling animals to be considered as victims. And that will be all. Thank you very much for your kind attention this afternoon.